Hi there and welcome to our webinar, which is going to give a case law update. Just an introduction, I'm Mark Clayton. I'm joined by my colleague Joe Hale and we are employment lawyers in the team. We've also got Thomas Bennett with us, who's our production assistant, and he's basically here to make sure we don't mess up any of the technology. So thank you in advance, Thomas. So we're going to just look at some of the interesting cases that have happened over the last 12 months or so. And it's really important to look at the case law that's happening because the legislation only takes you so far. And you need to look at the cases to see how judges and tribunals interpret the law. And it's a really good way to get an insight into the minds of judges. And there's a lot we can learn from that to hopefully stay out of too much trouble when we're managing people. So we're going to cover 6 cases today. It should take us around 40 minutes, I think, and then hopefully we've got a few minutes at the end for any questions. If you do have any questions, please use the Q&A function on Teams and we'll do our best to answer a couple at the end, as I said. So without further ado, I'll move on to the first case, which is about victimization. So the question is, was the removal of a Christian magistrate after he spoke to the press disapproving of same-sex adoptions victimization? So there've been a number of high-profile cases on the clash between sexual orientation rights and religious belief rights. And in section 27 of the Equality Act, there is a provision about victimization. Now, I'm sure for any of you who've dealt with lots of grievances before, you'll know that victimization is a term that employers often throw in there without any particular legal meaning. They say, you know, I've been victimized, but there is a legal definition of victimization, and it's where you're treated unfavorably or there's some detriment imposed for doing a protected act. So what is a protected act? Well, broadly, that's complaining about discrimination or helping someone else to complain about discrimination. Now, Mr. Page was a practicing Christian. He was a lay magistrate and he heard criminal and family cases. And when he started as a magistrate, he signed a declaration to act in a way that was free from sexual bias, amongst other things, and to maintain the reputation of the magistrate. And he was also given a guidance note and told not to communicate with the media. Now, in July 2014, he was hearing a case about same-sex adoption, and he expressed a view during the case that he had a problem with that. He had a problem with same-sex adoption. And this was reported to his managers, and after investigation, he was given a formal reprimand and told to undertake further equality training. In January 2015, an article appeared in the Mail Online about the case. And on the next slide, we've got a copy of the article. And you'll see there some of the quotes that he said, that they were saying that I was Christian and therefore I was prejudiced. And we all have our views, and that's what you bring to decision making, and mine are Christian views. And shortly after that article, he also appeared on BBC Breakfast News, in which he made a statement saying that he saw his responsibility was to consider what was in the best interest for the child, and his feeling was that it was in the best interest for the child to have a man and a woman as the adoptive parents. He also indicated or complained that he'd been disciplined for expressing his religious views as a Christian. So when his managers found out about these interviews that he'd given, he was disciplined. He was found guilty of misconduct, firstly, for ignoring the guidance on speaking to the media. Secondly, that his comments brought the magistrate into disrepute because his comments did not reflect the law. And thirdly, that his conduct was not as per his judicial oath that he'd given. He appealed internally, and although they found that he wasn't guilty of breaching the rule about speaking to the media, because they said it wasn't actually a rule, that it was merely guidance, so he hadn't breached any rules there, they said that his conduct did bring the magistrate into disrepute and he had breached his judicial oath. And it was recommended that he be removed from office because they thought that any reasonable person would now conclude that he was biased and that he would prejudice same-sex adopters, that he showed no insight into that, and that he maintained his views. So on the next slide, we'll look at the claims that he brought. So he brought various claims for direct and indirect discrimination because of his religious beliefs, for unjustified interference with his human rights under the European Convention of Human Rights, under Article 9, freedom of thought, conscience and religion, and for breach of Article 10, freedom of expression. And he also brought a victimisation claim. Now, I won't go through the detail of all of that, but suffice to say, at the employment tribunal, he was unsuccessful, and he appealed the Employment Appeal Tribunal on the issue of victimisation. And what the tribunal found was that his complaint to BBC Breakfast that he had been disciplined because he'd expressed his Christian views was a protected act. He was then complaining about discrimination. So that's the first box ticked for a victimisation claim. However, they said that that wasn't the reason that he was dismissed, that he was dismissed for contacting the media against the judicial guidance, for compromising their perceived independence and affecting their reputation, and for flouting his judicial oath. And they said that that was quite separable from the protected act. In fact, the protected act, this complaint about being reprimanded, was only a very small part of the whole picture. That was just one or two comments he'd made in his interview. And so they said that because it was separable, that his dismissal was not victimisation. So on the next slide, we'll just look at some of the points to take away. So firstly, freedom of expression is not an unfettered right. So you can restrict employees from expressing their opinions as long as you have a legitimate aim in doing so and it's proportionate. That if an employee breaches the workplace guidance and speaks to the press, they do risk being reprimanded and disciplined for that if it's against your rules. So you should check your policies, your social media policy, for example, to see if you do have clear guidance about what employees can and can't do online, and is there somewhere that it talks about speaking to the press. And the tribunals will carefully look at the reasons for disciplining an employee, and you may be able to separate the reasons from the protected act. So you've always got to pay close attention as to the reason why you're doing something, and it's always a good idea to make sure that's clearly documented in your dismissal letter or your warning letter, whatever the outcome is. So we'll now pass on to Joe to talk about a constructive dismissal case.
Thank you very much, Mark. Good morning, everyone. I do hope that you're all keeping safe and well. Moving on to constructive unfair dismissal. Just a quick reminder, an employee will be constructively dismissed if they terminate their employment contract with or without notice because of the conduct of the employer. That's set out in the Employment Rights Act 1996. And as Mark has been saying, we rely a lot on case law, and case law has established some principles when assessing constructive dismissal. And it has said that it will occur where there is a fundamental breach by the employer of an express or an implied term of the contract. It must be a breach that either goes to the heart of the contractual relationship between the employee and the employer, or a series of minor breaches, the last of which is the final straw. And the employee must resign with or without notice because of that breach or breaches. And of course, the employee must not delay unreasonably before resigning. Otherwise, they're considered to have waived the breach and essentially affirmed the contract. So decided that they're not bothered by the breach, and therefore they lose their right to any constructive unfair dismissal claim. A constructive dismissal is not always unfair, and the tribunal will look at an employer's conduct when deciding whether it had acted fairly or unfairly. Some of the things that you will have known about historically that have amounted to an unfair constructive dismissal are things such as failing to carry out an impartial grievance hearing or an impartial grievance appeal hearing, or indeed substantial delays in considering a grievance. Unilateral reductions in salary, for example, unless there was consultation and a good reason for doing so. Removing core duties from an employee is another thing that has amounted to constructive unfair dismissal. Discrimination, demotion, those are sorts of examples of constructive unfair dismissal. So we will see on the next slide that employees can resign because of a final act by the employer, commonly known as the last straw. In 2004, the Court of Appeal decision in Omolaju, sorry, I always get that wrong, doesn't matter how many times I say it, I do apologise. When they're looking at where an employee resigned because of a series of minor breaches, what the Court of Appeal said is the final straw must contribute something to the breach, although that contribution can be relatively insignificant. It mustn't be utterly trivial. It doesn't have to be of the same character as the earlier acts. It's not necessary to characterise the final straw as unreasonable or blameworthy conduct in isolation, but in most cases it's likely to be so. And an entirely innocuous act on the part of the employer cannot be a final straw, even if the employee genuinely but mistakenly interprets the act as hurtful. So it's essentially that last bit, an entirely innocuous act, that was considered on the next slide in the 2019 case. The Employment Appeal Tribunal, in this case, Williams and the governing body of Alderman Davis Church in Wales Primary School, gave consideration to this concept of the final straw. The employee, Mr. Williams, was a school teacher, and he'd been accused of a child protection issue, and he'd been suspended. He wasn't given any details of the alleged incident at the time. When social services found that no action should be taken, Mr. Williams was reinstated, but into non-teaching duties, whilst the school carried out an internal disciplinary investigation. During the course of that internal disciplinary investigation, the school discovered that Mr. Williams had downloaded certain documents and shared them with his trade union. Mr. Williams had said that he was just simply sharing information with his trade union that evidenced a history of poor treatment by the school. But the school thought he had breached data protection. So the school suspended him again because of that allegation of a data protection breach. And started another internal investigation. After several months, Mr. Williams wrote to the school, complaining about various aspects of his treatment. A few days later, Mr. Williams learned that one of his colleagues had been forbidden to contact him because he was under a similar investigation for a similar data protection breach. Mr. Williams decided that prohibition on the colleague contacting him was the last straw, and he resigned. When this was heard at first instance, the Employment Tribunal decided that the school's instruction to a colleague not to contact Mr. Williams until the connected disciplinary processes had been concluded was entirely reasonable and couldn't contribute to any earlier conduct of the school. And the tribunal therefore said that Mr. Williams did not resign as a consequence of a breach by the school. The school hadn't breached anything. If you remember, one of the requirements for an employee to succeed in a constructive unfair dismissal claim is that they must have resigned because of the breach. And in this instance, the tribunal said that what Mr. Williams had argued was the final straw couldn't have been because the school hadn't committed a breach. The tribunal had said it had followed the test set out in the Imalajo case. Sorry, again. But when this went to the EAT disagreed. The EAT decided that the situation with Mr. Williams was entirely different. The tribunal had actually failed to consider the possibility that the school's earlier conduct in itself amounted to a fundamental breach. Don't forget, Mr. Williams had complained about those earlier breaches by the school. He continued to complain about them. And he was saying that those earlier acts of the school contributed to his resignation. It was just his knowledge that a colleague had been prohibited from contacting him was what he considered to be the final straw. And what the EAT said was it was possible that a reasonable act by the school could revive the earlier fundamental breaches by the school. And this was the case even though the school's instruction to the colleague came at a later point in time and was the thing that tipped Mr. Williams into resigning. So even if the last act was innocuous, the employee may still be able to rely on a previous breach that had in this instance and would ordinarily be complained about as the final straw. The key question when you're thinking about the last straw was whether the series of acts taken cumulatively amounted to a fundamental breach. And that was the important distinguishing feature. Mark, you've got another case involving a teacher.
Yes, thanks, Joe. So I'm going to talk about an unfair dismissal case. So the question here is, was a teacher who was charged with possession of indecent images but not prosecuted unfairly dismissed? Now, K, as he was known, it was obviously an anonymised case, was a teacher with long service and an unblemished record. And in 2016, the police raided his home, having received intelligence that indecent images were downloaded to an IP address that was linked to him. And he lived at his home with his son, and they were both questioned about this. The police seized his computer, and it did have decent images on it. He was initially charged, but then, for an unknown reason, the police decided not to prosecute him, but to keep the case under review. The school where he worked suspended him whilst they investigated and went through a disciplinary process. Now, the school attempted to get more information about the case from the police, but they were unable to get anything of any real use. Everything that they got was very heavily redacted. So they had very little to base their investigation. Really, all they knew was that he'd been charged. Nevertheless, they invited him to a disciplinary hearing. And on the next slide, we've got the allegation that was made. So the allegation was being involved in a police investigation into illegal material of indecent child images on a computer found within your home and the relevance of this to your employment as a teacher. I don't think it's the most strongly worded allegation that I've seen. I think they could have done better. Let's see what happened in this case. So during the disciplinary hearing, he admitted that the images were found on his laptop, but he denied that he was responsible for them. He said that there were several ways those images could have ended up there. Others, for example, had access to his laptop, including his son and his son's friends, and any one of them could have been responsible for the images. The school accepted that they had insufficient evidence that he was responsible for the images, but they decided to dismiss him for two reasons. Firstly, they held there was an unacceptable risk to children if he were to return to work, in light of the fact that he may have been responsible for this, for the images. And secondly, they referred to reputational risk. So on the next slide, let's have a look at what they say about reputational risk. So they said that if in the future it was shown that he had committed the offence, then the council's reputation would be damaged if it became public knowledge that they were aware of the allegations and yet continued to employ him. So he claimed unfair dismissal after he was dismissed. And let's have a look on the next slide at what happened in the tribunal. So the tribunal rejected his unfair dismissal claim. They found that his dismissal was fair, and so he appealed to the Employment Appeal Tribunal. And there were two grounds to his appeal. The first one is that the allegation made no reference to reputational damage. If you remember, all it said was being involved in the police investigation into indecent child images and the relevance of this to your employment. And secondly, he said that the school had insufficient evidence to find any misconduct, and therefore the school should not have dismissed him based only on the possibility that he downloaded the images. On the next slide, let's have a look at what the EAT decided. So the EAT found, firstly, that reputational damage was not one of the allegations. It was mentioned in the investigation report, but that was not enough to make it an allegation. It had to be in the letter. And secondly, that on that point, the reputational damage had very different considerations to a misconduct dismissal, and he was not given the proper opportunity to respond to that allegation. And then secondly, they said that the school had applied the wrong standard of proof. If the school wanted to dismiss him for the misconduct, it needed to show that it had a reasonable belief that he'd done the misconduct based on the balance of probabilities. So a 51% belief or more. They couldn't, it wasn't open for them to dismiss him for misconduct merely on the basis that he might have done it. That wasn't enough. On the next slide, we'll look at the EAT's consideration, because the EAT, they went on to consider, but could the school have dismissed him fairly for potential reputational damage? And they found that not on these facts. They said there was no information about the nature or seriousness of the images. I mean, personally, I'm not really sure how that's relevant. They're either indecent or they're not, but that's what they said, that there was no information about why he was not prosecuted. There was an indication that unless the circumstances changed, then he would not be prosecuted. And there was no evidence of any press interest in the case. So they said they felt it wouldn't have been reasonable to dismiss him based on potential reputational damage. I have to say that these cases are always very fact sensitive. There's another case, for example, called Ofcom versus Leach that we have talked about in a previous session, where it was found to be fair to dismiss an employee based purely on an accusation of having indecent images. There were some distinguishing features to that case. The allegations were more clearly known. There'd been some other comments made by the police. I won't go into the detail, but it's always very fact sensitive. So what are the takeaway lessons? If we just have a look on the next slide. Firstly, it's so important that when you're setting out what the allegation is because if you don't clearly set that out, you run the risk of the process being unfair because the employee hasn't known the allegation before the hearing. And secondly, dismissing to protect your employer's reputation is not always straightforward. So you have to really carefully consider the evidence and assess whether adverse coverage is a real risk. I have to say, many employers will take the view that the risk to their reputation is a bigger risk than the risk of an unfair dismissal claim, and they'd rather be in the newspaper for having dismissed someone to protect the, for example, in this case, the children in the school than for an unfair dismissal. But nevertheless, there is an unfair dismissal risk. I'll now pass over to Joe to talk us through a restrictive covenant case.
Thank you, Mark. Just noticed a quick question that I can probably answer in relation to constructive unfair dismissal. Where an employee resigns and works their notice, but then goes on to claim constructive dismissal, does the fact that notice was worked have an impact on the likely success of the claim? Employees can successfully argue constructive unfair dismissal even if they give and serve and work contractual notice. It becomes more difficult where they work more than they're expected to, so more than their contractual notice, because then it suggests, well, why are you working more than necessary when you say that the employer has committed a fundamental breach? Why would you do that? So working contractual notice doesn't defeat a constructive unfair dismissal claim. I just thought I'd answer that one really quickly. So post-termination restrictive covenants. These divide our clients frequently, and it depends upon which side of the fence they're on at a particular point in time. It's perfectly allowable to have clauses in employment contracts that restrict employees and the work that they go off and do after they've left your employment. But such clauses in contracts have interested the courts for many years. And we know that clauses or terms that purport to restrict a person's ability to work after leaving one employer are considered void and a restraint of trade unless they are protecting a legitimate business interest and they are doing no more than is reasonable, having regard to the interests of both the parties, i.e. the need for the employee to work in a trade that they're familiar with and the need for the employer to protect its business interests. So, as we can see on the next slide, often former employers seeking to rely on restrictive covenants in ex-employees' contracts will bring claims against new employers, arguing that that new employer has induced their former employee to breach the restrictive covenants. The new employer is likely to be a more lucrative prospect to pursue than the previous employee. In order to bring a claim that a current employer is inducing a breach of restrictive covenants, you have to bring a claim in tort. hence the picture that is up there on the slides. So Allen, trading as David Allen Accountants versus Dodd & Co, considered to what extent a new employer was liable for inducing a breach of contract when it had received advice that the restrictions of its new recruit were unenforceable. This case went to the Court of Appeal. For a person to be liable for inducing a breach of contract, the contract had to be binding and enforceable. If not, the inducement could not cause any loss. Mr. Pollock had been employed by David Allen Accountants from 2007. In 2015, Mr. Pollock signed a new contract containing restrictive covenants, which applied for 12 months after the termination of his employment. On the 6th of July 2018, 3 years later, Mr. Pollock resigned to join a competitor, Dodd & Co. Dodd & Co had known that there was what appeared to be a contract, but had been advised that the relevant restrictions were probably unenforceable. That's as far as the legal advice went. Dodd & Co took this advice before taking Mr. Pollock on. The advice had said there was a lack of consideration, there'd been no money in entering into this 2015 contract with the new restrictive covenants. 12 months restrictions were too long. The non-solicitation clause was probably unenforceable, and the non-dealing clause was on balance likely to fail. So that's the advice that Dodd & Co had got. So when Dodd & Co took Mr. Pollock on, they knew that there was a risk, but they took him on anyway. The legal advice hadn't given a definitive answer either way. It had just said that the restrictions were probably unenforceable. So they took Mr. Pollock on, and they concluded that Mr. Pollock was free to contact his previous clients. When Dodd & Co originally took that advice, they had thought that Mr. Pollock hadn't received a pay rise when he signed the 2015 contract, but it later transpired that he had received a backdated pay rise. So David Allen Accountants brought claims against Mr. Pollock for breach of contract and Dodd & Co for inducing the breach. The Court of Appeal looked at all of the restrictive covenants, and they concluded that some parts of those restrictions could be severed from others, and that those that could be severed were in fact enforceable. And they concluded that Mr. Pollock had in fact been in breach of those restrictive covenants. But then they went on to consider whether Dodd & Co was liable for a breach of by inducing Mr. Pollock to breach those restrictive covenants. But what the Court of Appeal had said was that in order to be liable for inducement, Dodd & Co had to know that they were inducing a breach. They had to actually realise that the act of taking Mr. Pollock on would have the effect of breaching the contract. And it was for the claimant, in this instance, David Allen, to prove that Dodd & Co actually had knowledge of the breach. Dodd & Co had advice that the restrictions may not be enforceable. So this meant that Dodd & Co couldn't unequivocally know that they were inducing a breach. And so the Court of Appeal concluded that Dodd & Co were not guilty of inducing a breach of the restrictive covenants in this instance. And just for a final word, moving on to the next slide, the government has launched a further consultation on the reform of non-compete clauses in employment contracts. Because of the economic impact of COVID-19, the government is exploring the option of restricting the use of non-compete clauses. They want to be able to maximise individuals' opportunities to start new businesses and find new work. So they're seeking views on a couple of proposals. making non-compete clauses in contracts only enforceable if the employer actually compensates the employee for the period of the restrictions. That might also include an obligation that employers disclose the exact terms of restrictions, for example, before the start of the employment relationship, and perhaps even putting a statutory limit on the duration of those non-compete clauses. But they're also contemplating banning the non-compete clauses altogether. So go onto the government website and have your say if you've got something to say about post-termination restrictive covenants. Mark, I think you're now going on to talk about an equal pay case.
Yes, thanks, Jo. So, was it a breach of equal pay law where an employer could not justify a female HR executive's lower salary compared to her male colleagues? So let's look at the detail of this case on the next slide. So firstly, a little bit about the material factor defence. So an employer can pay a man more than a woman for doing equal work, but only if it can prove that the variation in pay is due to a material factor, which is not directly or indirectly discriminatory, which makes sense if you think about it. If you have two people being paid a different amount, one's a man, one's a woman, but you can show that the reason for that is an important reason that's not discriminatory, then you will not be liable for an equal pay claim. Now, the reason for that difference, it must cause the difference, but it doesn't need to be a good reason or one that the tribunal agrees with. So the facts of this case, in around March 2014, Mrs. Walker was promoted to Chief Human Resources Officer at the cooperative group. And the cooperative group was in financial crisis at the time, and Mrs. Walker and the rest of the executive team were considered essential to the survival of the business. And so they were all given pay rises. How lucky. However, the other executives were given a larger pay rise than she was. And in 2015, a job evaluation study was done, and it showed that she was paid less than the male members of the executive team for doing work of equal value. And so she claimed for equal pay. Now, the company argued there were various non-sex-based reasons for the difference. So essentially, it was running a material factor defence. Now, the decision of the tribunal was that the company did have a material factor defence initially because her comparators, the male colleagues in the executive team, were part of the core team, whereas she was not, that she was a newly promoted and unproven employee at executive level, that the male colleagues were more of a flight risk than she was, and that one of the comparators was a sort of described as a top corporate lawyer whose market rate was higher than hers, and that was the reason for the difference in pay. However, they went on to find that at some point between her promotion and the job evaluation study that they'd done in the following year, her relative value went up compared to her colleagues. So she was eventually doing work of equal value. And they said that the historical explanations for the difference in pay they were no longer material at some point between her promotion and the job evaluation study, and therefore she was entitled to equal pay at that point. And that was going to be determined what that point was at a separate hearing. And this was then appealed to the Employment Appeals Tribunal, and they basically tore apart the tribunal's reasoning. They didn't like it at all. What they said was that the material factor defence that the company had for the initial reason for the difference in pay would continue to operate until a further decision or omission to decide was made about pay. And at that point, the company would then be required to justify the difference in pay. But there was no evidence that there'd been any conscious decision to allow the difference in pay to continue. It was just a legacy reason. And at the time it was implemented, there was a material factor defence. So the key point here that the court said was that whether the difference in pay was justified was not the issue. It was whether it explained the difference. It's a very subtle but important distinction. You don't need to be able to justify the difference. You just need to be able to explain it. On the next slide, we'll look at some takeaway points from this case. So firstly, an equal pay claim will not succeed if you can demonstrate a material factor defence, and that you must prove that the reason for the difference is not sex and it's material, but you don't need to be able to justify it. Okay, so we'll now go back to Joe, who's going to talk us through our final case for today, which is the juicy topic of TUPE.
Thank you very much, Mark. As all of you who know me well will know, I always like to shoehorn a TUPE case in to these annual updates, and this one is an interesting and amusing one all at the same time, I think. Well, for people like me who get interested in TUPE. Just by way of a reminder, variations of employment contracts are ineffective if the reason for the variation is the transfer itself, unless, of course, there's an economic, technical or organisational reason entailing a change in the workforce, known as the ETO defence. Also, a point to note specifically about this case is that changes to terms can occur if they would have been possible if there had been no transfer at all, and the reason for that change is not the transfer itself. So you're, as the incoming employer, you're standing in the shoes of the old employer, and if you're allowed to make the changes because the contract allows for it, then you're allowed to do it as well as the incoming employer, provided, of course, that it is not because of the transfer itself, and unless, of course, you've got an ETO defence. So in the next slide, we look at the case of Ferguson and Estrella Asset Management Limited. In this case, the transferred employees, who were also directors and shareholders of the outgoing business, were seeking to rely on a beneficial change to their terms, which they had made in anticipation of the TUPE transfer, specifically to compensate them for the loss of the business, because it was going to transfer away. The transferring employees signed new contracts before a TUPE transfer that significantly improved their employment terms. It provided for a guaranteed annual bonus of 50% of their salary and a termination payment. So they were taken on by the transferee, but they were dismissed, and they brought employment tribunal proceedings for the unpaid termination payments. The employees had said that they were allowed to make the contractual changes and that they had occurred before the transfer had taken place. But the Employment Appeal Tribunal said that the varied terms were void under TUPE because those changes were made in contemplation of the transfer itself. So despite those changes being entirely positive for the employees, they were void. They'd been made because of the impending transfer. The EAT went on to say that the purpose of TUPE was to safeguard employees' rights, not to improve them, and there was ample evidence that the director's intention was to obtain an improper advantage by varying their contracts in contemplation of the transfer itself. So those positive changes to those contracts were void. And that brings us to the end of our formal presentation. I'll hand back to Mark.
Thanks, Joe. You get the impression that the tribunal were just never going to allow directors to increase their pay for a transfer and that to be permitted. So I suspect there was probably a bit of public policy reasons there.
I think there were. I think it's exactly the right decision. But I think some of our clients have seen how contracts have sort of all of a sudden changed just before a transfer. So I thought it was a good case to finish on.
Definitely. Okay, so we'll just, we're a bit behind schedule, but just have a look at a few questions that have come through. One of them, should we hear a grievance about discrimination after an employee has resigned? In simple terms, yes, I think you should. It can be a failure to follow the ACAS code not to hear a grievance. Not quite clear whether it applies to someone who's already left the employment, but the potential is there for an uplift. You may want, of course, to know the truth about the grievance, whether there has been any discrimination. And I think if the employer does bring a claim, it's probably not going to give a positive impression if you've just dismissed the complaint because the employee's resigned. So I would say generally, yes, I would. Joe, probably one for you. If the business has treated an employee badly, can this be cured to avoid a constructive dismissal?
Yeah, that's an interesting one, isn't it? It's not unilaterally, I think, is the answer. Obviously, what we're going to want to do as employers is try and put right anything that we think we've got wrong. And if the employee then accepts our remedy and accepts that our intervention satisfies them, then that is them effectively affirming the contract, if you like, and saying to us, okay, thank you, I'm not going to now rely on that breach because I'm satisfied with the remedy. So it's only really if the employee accepts your cure, if you like, that you can remedy a breach.
Thanks, Joe. I just have one more because I think we are a bit over time. So if a policy states you can't speak to the press, can we discipline and treat as gross misconduct? In principle, yes, you could discipline someone for speaking to the press against your rules, but you do need to be a bit careful, particularly where speaking to the press might be whistleblowing. There are certain circumstances in which an employee is allowed to speak to a third party, including the press, to whistleblow. But so you just want to have consider whether those conditions apply before you discipline. So it's definitely one to take advice on. Okay, I think that's probably everything we've got time for today. Thank you for attending the webinar. If you want to discuss any of the issues that we've raised, our contact details are on the slide there. We're always happy to have a chat with you about any of the issues. I think we should be sending the slides out as well, so watch out for them, and hopefully we'll see you at our next webinar, which is tomorrow at the same time, where we're going to be discussing the juicy topic of responding to data subject access requests. Thank you very much, everyone.
Thank you. Bye.